This is the judgment in the appeal between Zipvit and Her Majesty's Commissioners of Revenue and Customs. I am delivering this judgment on behalf of Lord Sales. Usually, when a supplier provides services to a trader which are subject to VAT, the supplier charges the trader the VAT on top of the commercial price for the services. The trader can, in due course, deduct that VAT as input tax in respect of goods which it sells to its own customer and on which it has to charge VAT in its turn. In this way, the trader recoups the VAT element which it has had to pay out. This case is about what happens when a supplier of services and a trader to whom it supplies the services make a mistake about whether VAT should be charged in relation to those services. Royal Mail supplied postal services to Zipvit, a trader selling vitamins and minerals by mail order. At the time of the supply of the postal services, it was incorrectly assumed that the supplies were exempt from VAT. The Royal Mail invoices stated that the supplies were exempt. Zipvit was only charged the commercial price with no VAT element. Having paid no VAT, Zipvit made no claim to recoup input VAT. However, later on, a judgment of the Court of Justice of the European Union, which I will call the CJEU, held that VAT should in fact have been charged on the supplies by Royal Mail. However, Royal Mail did not issue further invoices to charge Zipvit with the additional sums which should have been charged as VAT. Instead, Zipvit made a claim against HMRC. The claim was to treat part of the commercial price it had paid to Royal Mail for the postal services as if it had been VAT in relation to the notional reduced price, so that Zipvit could treat that notional VAT element as input tax, which it could claim back from HMRC. Zipvit claims that it was entitled to do this on the basis of a true interpretation of the relevant EU directive on VAT. Zipvit says it is entitled to recover this notional VAT from HMRC as input tax, even though Royal Mail did not appreciate that there was any VAT element in the price it charged and did not account to HMRC for such VAT. HMRC deny that the directive should be interpreted in this way. They say that to allow Zipvit to reclaim the notional VAT element would give it an unjustified windfall, since the effect would, in substance, be to reduce the price paid to Royal Mail below the true commercial price of the postal services which Zipvit received. HMRC deny that VAT has truly been paid by Zipvit in circumstances where, by mistake, none was charged. HMRC also say that under the directive, a claim can only be made for input VAT where the trader has a VAT invoice which shows the VAT which has been charged. But here, the invoices from Royal Mail show that no VAT was charged. Zipvit's claim to recover the notional VAT as input tax was rejected by the first-tier tribunal, the upper tribunal, and the Court of Appeal, but for different reasons in each case. This court has examined the case law of the CJEU bearing on the issues in this case. By unanimous decision, this court finds that this case law does not provide a clear answer to the issues posed by Zipvit's claim. It is common ground that, at this stage in the process of the United Kingdom's withdrawal from the European Union, in a case involving an issue of EU law which is not clear, this court is still obliged to refer that issue to the CJEU to obtain its advice on the point. Therefore, this court makes an order for a reference and sets out the question for the CJEU to answer to enable this court to determine whether Zipvit's claim is correctly made or not.